All right, Davis, we are all clear.
All right, I'm going to start with the Ethics Act statement. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. Well, I want to thank Lamar for sending those comments. I read them this morning, and I do like the format of kind of expanding the number of inquiries, maybe to try to take some of the. I think the substance Brian's put in there is great and necessary, and I think we can just make it more specific. But I wanted Brian to kind of explain his thoughts on where he was trying to kind of incorporate Lamar's thoughts into the current version.
Yeah. So, and just to, I know it's been a couple of weeks since we last met. So just where we're at, after the last meeting, I think we're trying to wrap our heads around just, what we think this opinion should say, what we think the answer should be, or really what the rules require the answer to be. But also to put it in a way that strikes that balance between offering guidance but doesn't try to micromanage lawyers' billing practices and so forth. And so the opinion that I sent out to you in mid-April, right before the meeting, basically tried to make it clear that lawyers can provide overlapping services to multiple clients. That absolutely, that's not really at issue. You can provide multiple clients the same legal service at the same time. The issue really is how you bill for it. And I think that was kind of some of the feedback that we were getting. And even though I may have tried before to make that point clear, I think the current version that I sent out to you tries to make that abundantly clear, that lawyers can provide services to multiple clients at the exact same time. How you bill for it is the other question, and really the crux of our inquiry. So opinion one just kind of clarifies that. Yes, you can provide multiple clients or services to multiple clients at the same time. Inquiry two is where you get into the real meat of it. And instead of, kind of setting out a scenario that from which we kind of let the rest of the opinion fall, which was, I think, the very first attempt that we had, when we focused on calendar call for multiple clients or the travel scenario. It just kind of starts very broad, and basically says, can you bill each client for those overlapping services? And the answer is yes, you can. It's not that providing overlapping services deprives a lawyer of their ability to receive compensation for those services. It's just that the billing structure needs to be accurate, it needs to be honest, not clearly excessive. And of course, that any sort of efficiencies are passed on to the client. Oh, and adds that point that we've mentioned a number of times, that the client needs to consent to the billing structure. And then you'll see in inquiry number two, we have the gist of the analysis and kind of the historic perspective on this topic. But then instead of getting into, like we said before, we had scenarios that drove the inquiries. The scenarios are reduced to examples, and to basically kind of set it out like, here's an example scenario. Here's kind of the answer to the question, can you, as far as, an impermissible billing structure for that scenario, but here's how you could permissibly bill each client for those overlapping services. Same thing when the example one, of course, is the calendar call example. Example two, that's within that inquiry, is the travel example. And again, the travel one follows that same sort of structure of, here's a scenario, here's what would be impermissible, followed by here's what would be permissible. And then of course the last inquiry is the same one about the unit billing that I think we've all agreed upon. The answer, of course, to these things, I think we arrived at the conclusion last time that, generally speaking, no, you can't bill for more hours than you actually expend on a particular matter. The example being you only do 1 hour of work for 4 different clients, you can't bill 4 hours. And the same thing with the travel, you can bill for your expenses if you're doing work while you're traveling. You can bill a travel fee, you can bill the mileage, you can bill the plane ticket, all that kind of stuff. But as far as actually billing the hours for travel while simultaneously billing the hours for work, that would be that same scenario, billing, 4 hours of work that only occurs over 1 hour, whatever it might be. So I think it's consistent in that regard. Lamar's structure, I thought, was really helpful to look at, and that's, I wanted to pass that along to you all, because Lamar suggested, that basically I feel like it kind of more clearly answers some of the controversial issues that we've been running into. And he starts off by basically, staying with opinion number one, leaving that clear that yes, you can provide multiple services to multiple clients at the same time. So first question, can you bill somebody an allocated portion of that hourly fee or whatever it may be? Yes, of course, that's something we've all agreed upon. That's one of the solutions that we have there in the examples. But then a new inquiry that basically says, well, how about, can you bill all at your hourly fee basis? You can bill an hour to each one of the clients that received these overlapping services, that collectively totals an amount of hourly or hours that are billed that exceeds what you actually spent on the topic, i.e. that I built 4 hours or billed 4 hours for 1 hour of actual work. And the answer to that one was no. And that would be kind of followed by the analysis of how we've said that, that would be inaccurate or what have you. But then kind of getting into and inserting some of these examples, calendar call, flying for the deposition, whatever it may be. And then but then turning it back, well, how about if we're not on the hourly fee basis? Because I think that's something that I have to pause and say, I think that's what we've all kind of come back to this issue, that there are multiple creative solutions here. It's the hourly fee, the full hourly fee billing, that seems to be the thorn in the side of this issue, where we think we all agree that no, you can't really do that. Just a full hour. That's the part that's inaccurate. But again, we've already said you can't do that. Then Lamar suggests going with essentially another inquiry that says, well, what about a non-hourly fee basis? And we say, yes, you can, as long as the client consents, and we give some examples there. So his essentially breaks it down into the different billing structures. It's not so much scenario-based as much as how are you going to bill? Full hourly rates that exceeds the amount of time that you actually spent? No. Some other creative manner, flat fee, et cetera? Yes. Allocating portions of an hour, can you bill for that? Yes, you can do that. And so I think the question today is maybe twofold. One would be substantively, the opinion that was sent out, is this the answer that we want to arrive at? And we think that is the appropriate answer under the rules. And then structurally, do you prefer the draft that I sent out, or should we morph it into kind of a draft or an opinion that focuses on the different types of billing options, and structure it in that regard to give folks perhaps a clearer direction on, can I bill on a full hourly basis in a way that exceeds the amount of time I actually spent? No. But can I do it creatively with some other non-hourly fee basis? Yes, as long as the client consents and so forth. So maybe that's really the focus of this meeting and where we should start. Maybe we can start substantively, because Lamar's structure really just kind of rearranges the substance of what was sent out. So if we agree on the substance, then we can tackle the structure.
I think on the at least for me, on the substance of it, the substantive aspect of it, at least it's going to lead us back to our prior issue on the travel thing. So I think the example number 2 under the current version is, I'm happy with it personally, but that's going to be where I think we might get pushback from others. Again, is differentiating travel from legal services the route we want to go. I don't know if this accomplishes that. I think this says, no, you can't do it. It goes back to our original thought. You can't do this. You have to charge one or the other, or charge some sort of creative travel structure.
So I'm sorry, go ahead.
That was all. I was just on the substantive aspect. That's the only question I have is we've kind of gone around in circles on that one, and I'm not sure if we've ever gotten an agreement on how we want to try to address it.
Okay. Just so I'm following this correctly, because Davis's question just triggered a question in my own mind, and I apologize. I'm not articulating it very well because it's still kind of inchoate. It's bubbling. It's bubbling to the surface here. But let me give you an example. I understand what we had before with, okay, you travel, bill at a cut rate because everyone knows you're in the car. You don't get your full $400 an hour. Maybe you get $200 an hour. And it's reduced because everybody knows you're probably listening to a baseball game or talking to your kids or, whatever. But under this new scenario, and but we said still, even with that discount, we're not going to allow you to take a 20-minute phone call about another case, and then at the end of the day, bill for my whole travel time plus the 20 minutes. Somehow I'm going to have to go in and subtract the 20 minutes from client A. Is what I'm hearing, though, the solution on the timepiece, because I think it's finally coming into place for me. This morning, 2 new cases I worked on. One is in Whiteville, that's Columbus County, and the other is in Franklin County. Now, from Raleigh, and I'm trying to just put this in pragmatic terms, like I think other attorneys are going to think about this. So from Raleigh, for me to go to Whiteville, let's say it's a 3-hour round trip, okay, depending on how fast I'm driving on those country roads. If I come up with a payment structure that says, and I just put it in my put it in the agreement initially, and it says, every time I travel for you, because in Columbus County and Whiteville, I'm going to have to go down there for motion hearings. I'm going to have to go down there for depositions. Okay, fine. And then ultimately the trial. So can I say, under this new model, every time I travel under 3 hours on your case, I'm billing you $200 an hour flat fee. Every time I travel between 3 and 5 hours for your case, I'm billing $220 an hour. And every time I travel 5 to 7 hours, because now this Columbus County, the Franklin County case is on the other side of Charlotte. Now I have an attorney in our local office who's going to kind of do all the nuts and bolts stuff, and I'll just zoom in for client meetings, but I'll have to be there for like the big SJ hearings and stuff like that in the trial, right? Now, when I'm driving to Franklin County, if I have a billing arrangement that says, anytime I travel between 7 and 10 hours round trip, I'm charging you $250 flat fee. No questions asked. That means that I can also, in my 7 hours on the drive, listen to books on tape, take another phone call from another case, FaceTime my kid from lacrosse practice. And I don't have any ethical problems. Is that a workaround here?
I think Jack, the for one, I know you said flat rate $220 an hour, and maybe that's what I want to clarify. You're talking like the 7 to 10 hours of travel. We're just going to call it.
I apologize. You pointed. I apologize. I didn't mean per hour. I meant a flat rate. If I'm traveling for you any period between, I don't charge you under an hour. I don't charge you.
Right.
Anytime I'm in the car for you between 2 and 4 hours, you're getting billed $300. Every time I'm in the car for you between 4 and 6 hours, you're getting $800. And every time I travel for you over 8 hours, it's $1,000. No questions asked. I'm just doing that. That's part of the case. And in the car, it doesn't matter if I'm listening to a New York Times podcast or talking on the phone on another case. That's a moot point.
Yeah.
Is that right?
Right. I think that's right. That essentially, if you have a flat rate that you can, like you said, you can listen to books on tape. I would say don't FaceTime your kid while you're driving.
I didn't say that. I didn't say that.
No, but yeah, you could listen to a book. You could take another call from a client for whom you're billing hourly. You know, and that was something I would say the whole allocated stuff. I was talking with some of the other lawyers just around here, and talking with some other friends that are out there in the practice and dealing with this more than just like the opinions that I'm drafting here, and just kind of asking, the burden of the allocation. If you travel for 3 hours and I bill those 3 hours, but I got there, I took a 20-minute call in the middle. I guess I'm getting the impression that lawyers are writing down that I took a 20-minute call because I want to bill that person for 20 minutes, whether I'm getting paid for travel or not. I'm recording that I took a 20-minute call. And so it doesn't seem like as much of a burden. And maybe I'm wrong. Maybe I'm talking to the wrong people of maybe removing that 20 minutes that I traveled for 3 hours. I'm going to take away 20 minutes because during 20 minutes of that travel time, I billed for another client. And so they're getting the 20 minutes and then I'm only charging that one client the 2 hours and 40 minutes. It's extra work for sure. But I guess I didn't get the impression from folks that it was unworkable. And so I think that is one option. The option that you provided, the flat fee, is another option under this opinion, that if you charge a flat fee like you described, $250 for 3 to 5 hours, you're getting $400 for 7 to 10 hours, whatever it may be, as long as it's not clearly excessive, and as long as it is it's something that the client consents to, then I think you have a flat fee to accomplish the task of traveling for that client. It's kind of like the flat fee for appearing at calendar call, a flat fee for accomplishing a specific task associated with the representation, during which you may end up doing other work for another client, but your flat fee is for the specific task of traveling from point A to point B for client. And so what you do during that time, I think you can take another call and bill.
I will tell you, this really, I'm very happy with that. That will work out well.
Yeah. I want to make sure everybody else agree with that would be my interpretation of the opinion and the application of the opinion. But if you all see it a different way, then that's important to note as well.
No, I agree. I think that was, I just want to make sure that's kind of where we're going with it, and that everybody's on, at least this subcommittee's on board with that kind of analysis.
Okay. Yeah, and I think it goes back to the point, and this is going to be that question of structurally, the big issue that I think we've run into, what has tripped us up, has been trying to apply an analysis that I think we feel comfortable applying to hourly billing, true hourly billing, to every other potential billing option. And that's where I think we're trying to, and I think maybe Lamar's structure does a better job of this, of really pulling out and saying hourly billing is the problem. And that structure is just unworkable today because you're essentially billing multiple hours. You're billing 4 hours for 1 hour of actual work, and that's just not accurate. That's what leads to what Catherine had pointed out before, the question of protecting the public, the message it sends to the public, things of that nature. And that's just going to be an inaccurate way to bill. But saying the client, getting the client's consent, there's a 4 hour travel window, anything between 2 and 4 hours, whatever it is this flat rate, and that's the cost for accomplishing the task. And I think that is what the opinion says, and frankly, probably what the opinion is encouraging lawyers to do, because it is more transparent. The client knows exactly what they're getting, and they know that they're paying for your travel, plain and simple, and not getting into the details, the nitty gritty of you just billed me for 3 hours of travel, but you were doing work during those 3 hours. Why do I have to pay for you to do work for someone else? Things of that nature. So anyway, that's kind of I think what the opinion says.
I will tell you, I feel better right at this moment about this topic than I have in all of our previous conversations, because it relieves any all of that potential ethical machinations that you had to do to figure out if you were doing right. It relieves you of all that burden.
Yeah.
Let me propose this on the structure. So I was trying to, I do think breaking it out into multiple inquiries helps from the reader standpoint. I also think giving specific examples can allow us to talk about each type of billing structure in the opinion. And so what if we did something like, obviously left number 1 alone, if we left number 2 alone, but drew the line just after the first paragraph, just said, yeah, you can do that. Then we get into inquiry 3, where we go to the court appearance example, where you're billing hourly for 4 people. Can you do that? No. And then you get into the what excessive is, the history about the dishonesty and all that. Then inquiry 4, you could bring in same facts as number 1, but instead of doing it, and go back to number 3, but if you're going to do it that rate, then you need to divide it amongst your clients in a quarter, 25% to each client. Inquiry 4 is same facts now, but you charge a flat fee instead. Can you do that? Yes. Inquiry 5, travel. You got the hourly rates for travel. Can you do that? No. If you're going to bill hourly, you've got to figure out who you're going to bill or prorate it in some fashion. Inquiry 6, same facts, except for you have a flat rate or a per diem travel. Yes, as long as it's agreed upon, it's not clearly excessive. And then issue 7, you wrap up with kind of the units billing. And so you've addressed small units, you've addressed travel in an hourly and flat rate fashion, and you've addressed court appearances and kind of legal time in an hourly and flat rate fashion.
I see exactly what you're saying, Davis. I think I might add one other thing in there, one other inquiry, which is because of the power and repetition, right? And what you had set out there with the court appearance, you've got the hourly billing, you've got the allocation of that hour amongst multiple clients, and then you've got the flat fee. And I would replicate that. So I would have an allocation inquiry that I would add to that travel.
Sure.
But that's it, because I think that would be, again, the power and repetition to say, I'm looking at this scenario. Is this billing structure okay? Basically, both of them say full hourly billing. Everybody gets an hour. That hammers home the point. No, you can't do that because that's inaccurate. But allocate stuff, yes, you can do that. That's accurate. Flat fee basis, and even, I think there's potential for other creative solutions or whatever. And I guess that's the thing where I don't want to say it's flat fee and nothing else. There may be something else out there that, again, if the client consents to the structure and it's not something that is exceeding what actually happened, then I think, we let lawyers exercise their professional judgment. And so I think that structure would work well. It does expand the inquiries, but again, it does so in a way that I think makes it probably more digestible for the reader. But I'd love to hear everyone else. Lamar, Jack, Judge, what do y'all think?
Well, I'm following along, and I tend to agree with you two on this one. And I like the way I like having it broken out, because I think that if we just put it out without it, we're going to get much more inquiries, which will be on the very topics that we already, Lamar suggested breaking it out. And so I think you answered my question, Brian. So Lamar, in your breakout, is that what you were intending when you stated non-hourly fee, that it could include other flat rate and other stuff? Okay, because that's I was wondering why you specifically said non-hourly fee as opposed to flat fee.
Yeah,
okay.
And I actually sort of struggle with how do I call everything other than
right
your hourly rate billing without it being wordy and redundant. And so, but that's ultimately why I said non-hourly fee basis.
I got you.
Exactly how, as Ron just articulated it, because there could be something other than a flat fee arrangement that's not a strict hourly fee.
And I'll add the example, we talk about flat fees in the meeting. I know one person had mentioned a per diem, stuff like that, which is going to be slightly different than a flat fee. It kind of is of the same nature, but it's slightly different. And I think that's the flexibility to allow. I mean, we could just go with, just whatever else the lawyer wants to do. We call it the other stuff. That's a very technical term to say the other stuff. But yeah, but no, I think that's what we're on that same page.
Yeah, that was the only question I had. I mean, I like the breakout because I just think if we don't do it, we're going to end up having to do it because we're going to have people making more inquiries.
That's very helpful.
And we do answer because I know we've had a lot of meetings. We have answered the original question.
Right.
And a lot more.
Right.
All right. Well, this is, I don't know if, just the lull here is maybe indicative of I think we are on the same page in terms of substance, structure wise. I want to break this out. And this has been helpful because I will tell you, I was trying to break it out at first after the quarterly meeting, but I guess just have not been able to sit down and really concentrate on that. But even when I was trying to break it out, there were little parts that I felt like, oh, this is going to be repetitive or something like that. And so this conversation, I think, has given me an idea of how we can really structure this to illustrate the point while also educating folks in a way of kind of not just what the answer is, but why the answer is. So I would, I don't want to prolong conversation or cut it short, but I know right now that I want to go back and restructure as we've discussed and send it out to you all. And I think that can be done fairly soon. And maybe we can see if we can schedule a meeting just before the quarterly meeting to see if we like this draft and present it to the committee in July.
That sounds great.
Sounds good. Ron, I have a question.
Yeah.
I don't know, there may not be a good way to do this, but it seems like when we've talked before, both in subcommittee and in the main committee meetings, one of the things that seemed to be important to people was the fact that doing something different than what our new first couple of opinions or inquiries and opinions would be going beyond what any other or any other state bar has done. I'm not articulating that very well, but this idea being we don't want to do something nobody else has done. We don't want to go out on that limb that nobody else has gone out on. And I'm just sitting here wondering if there's a way, be it in a footnote or something, to convey that to people so that when people are reading this and they're getting hot and bothered, but they can at least be told and they can understand that we're doing what everybody else. We're not, to do otherwise. To say otherwise, to do otherwise would mean essentially creating a whole new limb and walking out on it.
Yeah, no, I see exactly what you're saying, and it's true because I think what makes this opinion different is that the other opinions out there basically tell you what you can't do, but they don't tell you what you can.
Right.
And I think that's where we're trying to provide that guidance and some help instead of just posing the problem and putting up the parameters, but offer some avenues. And I see exactly what you're saying, and I like that. I'm just trying to think of how do you fit that in. Kind of to your point, is it a footnote? Is it something to kind of articulate? Is it something? You can always have there's journal articles and stuff like that to let folks know a little bit more about the behind the scenes, the development of this. But I don't.
I mean, if only you had comments like you would with a rule.
Yes,
it would be something you could comment, but you don't.
Right, exactly. And so that could be something that let me kind of simmer on that as I draft this, because if there's an opportunity there to show the distinction between our opinion and other opinions, that might be helpful, and it kind of gets out ahead of potential complaints. But the end of the day, I don't know if people are going to be complaining about it, maybe they're not going to be satisfied with the footnote explanation anyway. So I'll look for it though. I think it's a great thought.
I'm not sure. I see your point, but I'm concerned that if we were to do something like that, people are going to look at the other ones and trying to figure out why we didn't have more inquiries, because the other ones may include some more or less than what we have. And so that's what I'm concerned about. But then, of course, we are the ones that actually read this stuff. A lot of people don't. But the ones that do are the ones that's really going to pay attention to some stuff and really have a lot to say.
Right.
I think what you're proposing would have been good if it was like some ABA model rule or model opinion or something, but I don't know we have that in this situation. Right, Brian?
Yeah, I and that's where I think that's why I'm like, and I think Lamar, even in posing the question, you're trying to figure out how does this look? And that's why I want to get into the opinion, restructure it, and see. I think sometimes just having it in front of you, it kind of shows the opportunity if it exists, and it might be if it feels forced, then it's not going to flow, and I think that's just something we can be sensitive about. But otherwise, I'll take a look at that, restructure this with that in mind. And if there's something that just feels like it naturally can fit in a particular spot, then we'll try it out, because this is drafting stage, and we get some feedback.
I think long term, like down the road, where we can get that in what you're talking about or cover some of this is, I know we had talked about it in another committee, and just overall having some of these things on like modules. What's the committee? The PMB, it's not called
PMBR. Yes.
Right. So that one where we have those modules, and maybe folks can this could be one of those topics where people can get on there and they can have different scenarios and they can do the little, you know what I mean, kind of work through it. This will be one of those great topics for that.
Yeah. And billing was one of the topics that was highlighted as an opportunity that folks would enjoy, or maybe not enjoy. They would appreciate some guidance. Enjoy would be too strong of a word, but
it can have like some scenarios and people, kind of inputting information. And like, if you have these two things, what do you do in this circumstance, or what are your options in this circumstance? Something like, I think that'd be good. Or one of those little what we were talking about in communications too, Brian, having some Zoom meetings or some kind of webinars. This will be a good one for that too.
Right.
And then saying there, Lamar, we're not the first state to do this, and this is.
I mean, in the meantime, I'll say, the only opportunities that I have to really make that statement is usually in the CLE. Examples being earlier this week, I gave a CLE where I was highlighting the fact that we are the first state in the United States to prohibit inappropriate pictures being sent between lawyer and client. And that always gets a laugh and a reaction, and kind of I'm so sad that we have to have this rule, but at the same time, it's important to note, in our attempt to be relevant and, to make sure that the rules are addressing the concerns of practice. Sadly, that's a concern. So, but yeah, I'll see if I can find a spot.
Good stuff. So you got some more work, Brian?
Yeah, we're good to go. Mr. Chair, is there anything else that you want to cover, or any other ideas that you think we need to discuss at this point?
No, I think it would just be good if we can, if we try to do one, we're going to do another committee meeting before or the subcommittee meeting before the July meeting. Be good to do it early enough so that we can incorporate any changes from that meeting into the version that we're going to submit to the full committee.
Right. And I was going to suggest, I don't know. I mean, I know we get into travel schedules and all that kind of stuff. But if we shot for sometime maybe in the last 2 weeks of June, either June 19th or June 26th, I'll ask Lanice to send out a poll to gauge everyone's availability. And like I said, I've got some stuff coming up that's going to keep me out of the office. But I think this structure is something that I can put together and send out hopefully within a week from today. And we can get that thing kind of in front of you. You digest it, get some let it sit for a little bit, and we can meet then. So I'll send out that poll, or have Lenny send that out, and we'll shoot to get it one more meeting there.
Cool.
Cool.
Thank you, Brian, for all your hard work as
Yeah,
always.
thank you. Appreciate
Oh,
everybody
yes.
being here today.
Yes, sir. You all have
Yes.
a
Great
good
seeing
one.
everybody.
All righty. Have a good
All right.
Memorial Day weekend, and we'll see you soon.
Yes. You too.
Y'all be
Okay.
safe. Thank you.